This is an introduction to initial interest confusion on the internet. It's important to understand how we got to this point because a lot of the case law remains on the books and we will undoubtedly face new technologies in the future. We should probably learn from our past mistakes. So I'm going to discuss a few cases that got us to the network automation case. Starting with Brookfield versus West Coast Entertainment, a Ninth Circuit case about the use of moviebuff.com and moviebuff in the meta tags for a website. Here, meta tag for these purposes is used in the code of a website. It's visible to computers indexing the site, but not to consumers. Brookfield owned rights in MovieBuff, one word, as a mark for its database software. West Coast then registered the domain name moviebuff.com and used it for a similar database of movie information and then put MovieBuff in the meta tags. The court found infringement both in the domain name and the meta tags and found initial interest confusion for the latter. The court said, since it's easier to enter a website than a physical store, consumers will pay less attention to what they're doing, and thus they will be more easily confused about the ownership of a website than about the ownership of a physical store. Importantly, the court also used an analogy to the physical world, saying that West Coast got customers unfairly through the meta tags as if they'd put up a billboard on a highway saying Blockbuster Movies Next Exit. When the customer got off the highway, she'd find West Coast Video instead of Blockbuster, but she might think that West Coast was perfectly acceptable and rent there instead. So this was a classic bait and switch. It was widely recognized, though not initially by courts, that this was a terrible analogy to what using the internet is like. Among other things, the sunk costs of navigating to one web page are much lower and people more readily click away if they want something else. So the next important older case, also not explicitly discussed in the text, is Playboy versus Netscape. So here, what we have are ads, keyword buys. Netscape sold a package of adult-oriented terms to advertisers, including Playboy and Playmate. When a searcher entered one of those terms, they'd get a list of results in the search engine and a separate sponsored banner ad. Playboy sued for infringement, and the Court of Appeals reversed a grant of summary judgment for defendants. Among other things, Playboy produced a consumer survey that purported to show that consumers thought that Playboy sponsored or was otherwise associated with the banner ad. In addition, the Court of Appeals thought that consumer sophistication would be low. It said, we presume that the average searcher seeking adult-oriented materials on the internet is easily diverted from a specific product he or she is seeking if other options, particularly graphic ones, appear more quickly. So one alternate theory, people know usually what turns them on. If it's not the exact level of titillation that's right for them, they'll keep looking. Consider what sort of evidence you would want one way or the other. Judge Berzon concurred in Netscape, and her concurrence became highly influential in later cases. She argued that there's a difference between initial interest confusion and initial interest distraction or diversion, and that correct labeling of results is generally enough to give the trademark owner everything to which it is entitled. The concern is that cases of alleged initial interest confusion may involve substantial social benefit to consumers by offering them relevant options, even if they do noticeable and real harm to trademark owners, precisely because consumers are now aware that there's an alternative. So this is the background that gets us to network automation, where the network automation buys the keyword active batch, the name of its competitor's trademark. The district court finds infringement based on what it called the internet trio: similarity of marks, similarity of goods, and similarity of marketing channels, which were supposedly particularly important on the internet, which is to say, initial interest confusion had then been encoded entirely into the multi-factor test. The Court of Appeals instead rereads prior cases as being about proper labeling. This rewrites history, but it is the right result. And that gives you the introduction that we'll need in order to talk about initial interest confusion on the internet. Thanks.